Hello everyone, good afternoon. My name is Pietro Stefanini and I'm a Postdoctoral Fellow at the University of Edinburgh, and I'm glad to moderate this panel today organized by the Palestinian Return Centre titled Israel's Unlawful Carceral System, the Rights of Palestinian Political Prisoners. And before we proceed, I want to give a trigger warning that sexual assault and graphic violence may be part of the discussion, so it is important that you are all aware of that. Also, please do not take any pictures or recording. Only the organizers are authorized. And to briefly contextualize the three presentations, I want to just quote a brief passage from the latest report of the UN Special Rapporteur on Palestine, which is being discussed today at the Human Rights Council. And the report concludes that since October 7th, and I quote, Palestinian captives have been subjected to exceptionally ruthless physical and psychological abuse on a scale and with an intensity without precedent in the history of Palestine and Israel. Brutal beating, sexual violence, rape, lethal mistreatment, starvation, and the systematic deprivation of the most basic human conditions have inflicted profound and lasting scars on the bodies and minds of tens of thousands of Palestinians and their loved ones. These practices demonstrate that Israel's detention system has descended into a regime of systemic and widespread humiliation, coercion, and terror, aimed at stripping Palestinians not only of their liberty, but of their dignity, identity, and even the most basic sense of humanity. Far from isolated excesses, such a conduct has been institutionalized within detention structures, politically endorsed by Israeli authorities, and publicly justified or even celebrated by segments of society. I will not add much more for now, as we don't have much time, and I'd like to leave space for our speakers to present and answer questions at the end if we have time. And I will now introduce our first speaker, who will present in Arabic. We have translation for us. And Khaled Mahajneh is a human rights lawyer who has recently represented many prisoners from Gaza and the West Bank in Israeli courts. He was the first lawyer to visit the Sde Tayman detention center, where thousands of Palestinians from Gaza have been confined under horrific conditions. So I'm sure he has some important insights and perspective to share with us. And he will talk about the major changes since October 7 in prisoners' conditions from Gaza and the concentration camps that were established since the genocide has begun. Khaled, you will have 15 minutes.
مساء الخير لكم جميعا، وشكرا على الاستضافة. بالحقيقة شكرا على إتاحة الفرصة وإعطاء مساحة للحديث عن واحدة من أهم الملفات اليوم اللي تواجه الشعب العربي الفلسطيني، وهو موضوع الأسرى الفلسطينيين داخل السجون الإسرائيلية. عمليا منذ الحرب على غزة، منذ اليوم الأول للسابع من أكتوبر، بالتوازي مع الحرب الإجرامية التي مارستها إسرائيل على قطاع غزة، بدأت إسرائيل بحرب موازية على الأسرى الفلسطينيين داخل السجون الإسرائيلية، بحرب بإعطاء الضوء الأخضر من الوزير الفاشي بن غفير لكل السجانين الإسرائيليين بإعدام الأسرى وبانتهاك إنسانية الأسرى. وجئت إلى هنا، يعني هذه الفرصة الأولى أتحدث في هذا المكان، جئت إلى هنا لأنقل شهادات، لا أتحدث بالقانون ولا بالسياسة، إنما لأنقل شهادات أسرى يعذبوا يوميا منذ السابع من أكتوبر. أنا لا أتحدث فقط عن أسرى من قطاع غزة والضفة الغربية والقدس، إنما هناك أسرى أيضا سوريين وأسرى لبنانيين بالعشرات يمارس بحقهم أبشع وسائل التعذيب والتنكيل. عمليا الحرب التي بدأتها إسرائيل على الأسرى مع بداية الحرب على غزة تمثلت بعدة أمور وتفاصيل. بداية منع الأهالي من زيارة الأسرى من زيارة الأهالي نهائيا. منذ السابع من أكتوبر حتى اليوم لم تزر عائلة فلسطينية أو لبنانية أو سورية أبنائها داخل السجون الإسرائيلية، بالإضافة إلى منع المحامين على مدار أشهر طويلة من لقاء موكليهم الأسرى. والأهم كان هو الصليب الأحمر، منع الصليب الأحمر وهي المؤسسة الدولية التي كانت تعني بزيارات الأسرى والوقوف عند كل تفاصيل اعتقالهم. منعت الصليب الأحمر، إسرائيل منعت الصليب الأحمر من زيارة الأسرى نهائيا حتى هذا اليوم، والقرار ما زال مستمر. ولكن هناك تفاصيل أصبحت، يعني أنا كمحامي أعمل في هذا المجال منذ أكثر من 17 عام، تابعت ورافقت العديد من الأسرى الفلسطينيين داخل السجون، ولكن أصبحت التفاصيل تفوق كل المنطق والخيال التي تمارسها إسرائيل منذ أكثر من عامين. يعني حتى موضوع على سبيل المثال، وأبدأ من هنا بالتفاصيل والشهادات، موضوع الطعام، عن كيفية وزير إسرائيلي يتحكم بالسعرات الحرارية ووجبات الطعام التي تقدم للأسرى يوميا منذ أكثر من عامين. نتخيل جميعا في هذا العالم أن أسرى بنهاية المطاف هم بشر يأكلون نفس وجبات الطعام على مدار أكثر من عامين، بالصباح وفي الفطور والغداء والعشاء، نفس وجبة الطعام، نفس نوعية الطعام، ونفس سوء الطعام الذي يقدم لهؤلاء الأسرى. طبعا الطعام يقدم بدون سكر، بدون أي مكونات أخرى، ممنوعون من شرب المحليات والمشروبات الأخرى، فقط المياه، والمياه يشربونها، يجبرون على شرب المياه من المراحيض بدون بتزويد الأسرى بمياه طبيعية ونقية. بالإضافة إلى منع الأسرى من تبديل الملابس. تخيلوا أن هناك أسرى بدون مبالغة، بالذات أسرى غزة، لم يبدلوا ملابسهم منذ أكثر من عامين. كل أسير له الملابس الخاصة به، يبدل هذه الملابس، يستحم ويلبس نفس الملابس على مدار أكثر من عامين، بالذات الملابس الداخلية. وهنا الذي عمليا هذه جزء من السياسة الإسرائيلية التي إسرائيل تمارسها منذ أكثر من عامين، من أجل انتشار الأمراض داخل السجون، من أجل أدت لاحقا إلى موت واستشهاد الأسرى داخل السجون الإسرائيلية. ولكن كان الأكثر إيلام والأكثر موجع من متابعتي لهذه التفاصيل وزيارات الأسرى، أنا كمحامي والعشرات من المحامين نعمل في هذا المجال المؤسسات الحقوقية، هو موضوع المعسكرات السرية الإسرائيلية التي كانت مخفية كليا عن كل العالم، بدون أن تكشف إسرائيل أي معلومات عن وجود معسكرات سرية إسرائيلية موجودة حتى اليوم. قامت إسرائيل باستحداثها وابتكارها وإنشائها مع بداية الحرب على غزة، بالأساس من أجل اعتقال وزج المئات بل الآلاف من أسرى غزة وأسرى لبنان وأسرى سوريا داخل هذه المعسكرات. يعني أنا كنت أول محامي أدخل لهذه المعسكرات بعد أشهر طويلة من المعاناة والمطالبات من السلطات الإسرائيلية بزيارة معسكر سدي تيمان، وأحد السجون المعسكرات السرية الإسرائيلية في صحراء النقب. هذا المعسكر عبارة عن منشأة عسكرية، ولكن إسرائيل مع بداية الحرب على غزة قامت بتحويل هذا المعسكر إلى مكان لاحتجاز ناس، نساء، أطفال، مسنين، رجال، أطباء، محامون، ممرضون، مدرسون، أشخاص عاديون من قطاع غزة. فأنا قمت بزيارة أسير اسمه محمد عرب، وهو صحفي يعمل في التلفزيون العربي في قطر، اعتقل أثناء قيامه بواجبها المهني وتغطية الحرب على غزة. زرته بعد 100 يوم من الاعتقال. الزيارة أنا شخصيا لم أكن مهيأ لهذه الزيارة من ناحية نفسية كإنسان بنهاية المطاف. هذا المكان جدا مخيف، تفاصيل هذا المكان ما زالت ترافقني حتى اليوم كإنسان أعيش في هذا الكون. وكان المؤلم أكثر أن أستمع إلى شهادة الأسير على مدار 40 دقيقة، بالذات ما تمارسه إسرائيل بحق أسرى غزة في هذا المعسكر. بسبب ضيق الوقت أحاول أن أعرج على كل التفاصيل. نتخيل أن ما زال هناك أسرى من قطاع غزة يعيشون داخل هذا المعسكر ومعسكرات سرية أخرى، مقيدي الأيدي والأرجل منذ أكثر من عامين. يعني إنسان يبقى مقيد اليدين والرجلين بقيود حديدية منذ أكثر من عامين حتى اليوم، ويأكل وينام ويصلي ويضرب وينتهك ويغتصب وهو مقيد اليدين والرجلين داخل هذا المعسكر. عدا أن في هذا المعسكر لا يوجد كما في كل السجون بالعالم هناك أقسام وهناك أماكن خاصة لكل الأسرى وغرف خاصة للأسرى. في هذا المكان عبارة عن ساحة واحدة، كل أسير مرسوم له حيز دائرة صغير. هذا هو المكان الخاص لكل الأسرى، هذا الحيز الخاص لكل أسير. في هذا المكان يبقى الإنسان على مدار أشهر طويلة، يأكل داخل هذه الدائرة وينام داخل هذه الدائرة ويمارس كل حياته داخل هذه الدائرة. يسمح للأسرى بفك أو يتم فك القيود الحديدية فقط عند الاستحمام. الاستحمام عبارة عن مرة واحدة أسبوعيا، كل نهاية أسبوع لمدة دقيقة واحدة على الأسير أن يستحم ويلبس الملابس من جديد، الملابس الوسخة، الملابس التي يلبسها منذ أشهر طويلة. وحين بالإضافة حين يأكل الأسير يسمح له بفك القيود الحديدية. عدا عن هذا يبقى بنفس الوضعية، وبالذات عصبة العين. الأسير يبقى لأشهر طويلة معصوب الأعين بكل فترة اعتقاله حتى يخرج من هذا المكان. الخروج من معسكر ازديتمان معسكرات أخرى هي إما الموت وإما التحرر، لا مكان آخر، أو انتقال طبعا إلى مكان اعتقال آخر لا يقل إجراما وانتهاكا. ولكن الأكثر كان صعوبة لي أنا كمحامي وكإنسان أستمع لشهادات أسرى منذ أكثر من 17 عام، وأنا أعمل في ظل أنا محامي فلسطيني إسرائيلي أعمل في ظل المحاكم الإسرائيلية وأتبع لنقابة المحامين الإسرائيليين. لم أتخيل يوم من الأيام أن أستمع إلى شهادات تفوق المنطق والخيال من ممارسات، بالذات عن موضوع الاغتصاب. أنا لم أتخيل وأتوقع في يوم من في حياتي المهنية أن أستمع إلى أن أسير يغتصب داخل السجون الإسرائيلية. ولكن هذا الواقع للأسف، هذا الواقع للعالم أن يعرف وأن يعي ما تمارسه إسرائيل بحق أسرى غزة. من شهادة الأسير محمد عرب استمعت حينها إلى 6 حالات اغتصاب مورست بحق أسرى غزيين. واحدة من هؤلاء، يعني أنا أتأثر من جديد عندما أتحدث بالذات عن هذا الموضوع، أن ينتهك إنسان بجسده بواسطة مجندين ومجندات إسرائيليين، بواسطة إناث ورجال إسرائيليين من المجندين. حالتين من هؤلاء الحالات التي ما زلت أتذكر، وسوف أتذكر ما زلت حي أنقل للعالم كلهم ما عن هاتين الحالتين. أن يغتصب مسن يبلغ من العمر 67 عام من قطاع غزة بدون أي ذنب، مسن أصلا معتقل بدون تهمة بدون محاكمة، اعتقاله كان تعسفي كاعتقال الآلاف من قطاع غزة، بسبب أنه يطلب أمر ما من المجندين الحصول على أكثر طعام بزيادة طعام وزيادة ماء. تم اغتصاب هذا الأسير. اغتصاب هذا الأسير كان أنه تم سحبه من داخل الحيز الشخصي الدائرة الخاصة ووضعه في ساحة المعتقل أمام كل الأسرى وتجريده من كل الملابس بما فيها الداخلية. طبعا الأسير يكون مقيد اليدين والرجلين ومعصوب الأعين، لا يرى أي شيء. يجبر الأسير على النوم على بطنه، وبكل بساطة تأتي أحد المجندات الإسرائيليات بإدخال عصا، يعني عذرا على الكلام السيء والصعب، بإدخال عصا لمؤخرة هذا الأسير المسن لدقائق معدودة. وكان الأكثر مؤلم هو الضحك والاستهتار وتوثيق الحالة. يعني المجندين يوثقون حالة الاغتصاب والتحرش الجنسي بالأسير بجوالاتهم الخاصة، وتناقل هذه المشاهد عبر مجموعات الواتساب ومجموعات التواصل الاجتماعي. وللأسف الأسير يغتصب، يبقى دقائق معدودة بهذه الوضعية، والأسير لا يرى ما يمارس بحقه، إنما يشعر ما يمارس ويشم رائحة دمائه التي تنزف منه بسبب اغتصابه. ويعاد الأسير إلى هذا المكان، وبعد ساعات الأسير يلقى حتفه يموت داخل هذا المعسكر. فالكل يسأل، طب عمليا أنا تحدثت منذ دقائق أن كل الأسرى معصوبي الأعين، فكيف يتم أن يشاهد الأسرى هذا المشهد؟ فالجواب هو واضح، وهذا جزء من السياسة، أن المجندين يجبرون الأسرى على إزاحة عصبة العين لمشاهدة حلقة من حلقات الاغتصاب، لكي يوجهوا رسائل واضحة أن كل من يخالف الأوامر بداخل هذا المعسكر وكل من يتجرأ أن يطلب أمر بسيط، أمر إنساني بسيط، ممكن أن يغتصب في داخل هذا المكان. عدا عن حالة أخرى أتوقع لا يوجد أحد أن يتخيل هذا الحدث. شاب يبلغ من العمر 28 عام بسبب أنه حاول أن يدافع عن نفسه ويقاوم المجندين من التعرض له بالضرب، يسحب أيضا إلى داخل الساحة، يجرد من ملابسه. أحد المجندين يأتي بمطفأة الحرائق، الكل يعرف أعتقد مطفأة الحرائق حمراء اللون، هذه التي تكون موزعة بالعمارات والبنايات والمطاعم. يأتي أحد الجنود وللأسف يدخل أنبوب مطفأة الحرائق، وعذرا على الكلام والوصف ولكن هذا الواقع، يدخل أنبوب مطفأة الحرائق إلى داخل مؤخرة الأسير، ويتم ضخ المادة الكيماوية بيضاء اللون إلى داخل مؤخرة هذا الأسير. هذا الأسير بقي بالاعتقال لأشهر طويلة، فقد أهليته العقلية كليا بسبب ما مورس معه، وتحرر لاحقا بإحدى صفقات التبادل الأخيرة بين إسرائيل وحماس. ولكن وضعية حسب ما المعلومات التي تلقيتها مؤخرا، وضعية هذا الأسير النفسية والصحية صعبة جدا وسيئة. أتحدث عن حالتين، ولكن هناك حالات أخرى بالعشرات مورست بحقهم اغتصاب بالأساس. وهناك أسيرات، هناك أسيرة محررة من قطاع غزة روت للعالم أجمع عبر وسائل الإعلام وتوثيق شهادتها للعالم عن كيفية اغتصابها 4 مرات. امرأة تبلغ من العمر 42 عام، امرأة لأطفال ولشباب، تغتصب داخل معسكرات الجيش الإسرائيلي 4 مرات من الجنود الإسرائيليين. وتقول أقتبس بمختصر: أمرني الجنود أن أجلس على ركبي، أنا و6 معتقلين اغتصبونا بوضع الزجاجة في فتحة عمليا مؤخرتها، ويدخلون ويخرجون هذه الزجاجة، وكان الإدخال والإخراج عبارة عن 10 مرات. حاولت أن أصرخ ودافع عن نفسي. هذه الحالة كانت مرتين وحدي، ومرتين أنا و6 أشخاص. نتخيل كيف يتم اغتصاب نساء، اغتصاب رجال. وأنتقل لموضوع آخر وهو موضوع الطب، وهذا موضوع مؤلم أيضا. كيفية أطباء إسرائيليين، أطباء مدنيين إسرائيليين هم جزء من الإجرام الذي مورس بحق الأسرى، بقيامهم أن يقومون ببتر أطراف أسرى. حين يكون الأسير أكثر من 100 يوم و200 يوم مقيد اليدين، يتسبب للأسرى أوجاع، يتسبب للأسرى تآكل اللحم. فبدل أن يقدم لهم العلاج، كانوا الأطباء الإسرائيليين يبترون أطراف أسرى. وكان المؤلم هنا بشهادات الأسرى وشهادة الأسير محمد عرب أن بتر الأطراف يكون بدون تخدير. تخيل إنسان يدخل بحاجة لتخدير، إنسان مريض بحاجة للتخدير لكي لا يشعر بوجعه. إنما في السجون الإسرائيلية أصبح الطب هو أداة للتنكيل وتعذيب الأسرى ببتر أطرافهم بدون تخدير، والأسير لا يرى لا يشاهد، إنما فقط يشم رائحة دمائه ويشعر ما يمارس بحقه. الوقت بحاجة لوقت، الأمر بحاجة لوقت أطول لشرح ما تمارسه إسرائيل بحق الأسرى. ولكن حتى اليوم أكثر من 10,000 أسير بالسجون الإسرائيلية، وهنا أنهي، تمارس بحقهم يوميا تفاصيل مرعبة جدا. وتستغل إسرائيل كل حالة حرب، وبالذات اليوم الحرب المستمرة والقائمة مع إيران، تستغل بعزل الأسرى نهائيا وتعذيب الأسرى بعيدا عن أعين العالم. جئت إلى هنا من أجل أن أنقل نبذة بسيطة وقصيرة عن ما تمارسه إسرائيل، لعل وعسى العالم أن يستيقظ من هذه الغيبوبة ويجبر إسرائيل على وقف الإجرام والحرب بحق الأسرى هناك. شكرا.
Thank you very much, Khaled, for sharing your testimony. And it was for some parts difficult to hear, but hopefully It's an important testimony that can inform the actions of policymakers in this venue and in other venues where justice can be ultimately achieved. And I'll introduce now our second speaker, Muna Haddad, who is a human rights lawyer, and she's currently completing a PhD in law at Queen Mary, University of London. And she will discuss Israel's broader policy of using prisoners as bargaining chips in exchanges, and how this logic has been extended to corpses, including those of political prisoners.
Thank you for being here. It's that was. We keep hearing about the situation of prisoners time after time, and it's never easy. So yes, I want to turn to talk about another dimension of Israel's violation, and namely its abuse of the Palestinian dead, including the bodies held in Israeli custody and those of prisoners who have died in Israeli detention. Khaled has outlined the conditions under which Palestinian prisoners are held, where the body is subjected to sustained control, torture, and cruel and inhuman treatment. This form of control does not end with the living. Since the 7th of October 2023, it has become especially visible in Gaza in the treatment of the dead, and it extended to the prisoners as well. So what is at stake here is the treatment of the Palestinian body across the boundary between life and death. So in Gaza, Israeli forces have used mass graves to defile, conceal, and disappear dead bodies. We have also seen bulldozers violently removing remains to unmarked locations. We have seen weaponry so destructive that bodies are reduced to fragments that family are left to collect in plastic bags, with other remains lying scattered across streets or still trapped beneath the rubble of what were once their homes and shelters. While the Palestinian civil defense and surviving families struggle to recover and shroud these remains with dignity, Israeli forces have repeatedly cordoned off, seized, or disappeared them entirely. These scenes have become a haunting constant on our screens as Israel perpetrates what has been described as the most transparent genocide in human history. These violations are neither the inevitable aftermath of genocide nor its incidental consequences. They are the product of deliberate practice, and as scholars have shown, destruction, concealment, and manipulation of bodies are integral components of mass violence. A perpetrator's treatment of the corpse is rarely random, but is structured, reflecting broader ideological and organizational logics. In this case, the colonial violence, ethnic cleansing, and the destruction of lives that Israel inflicts on Palestinians. And this did not escape Palestinian political prisoners and detainees held in Israeli military camps and prisons. While alive, again, as Khaled has described, prisoners are subjected to conditions of abuse beyond imagination. Ear-splitting music played without stop, days spent blindfolded, forced nakedness, beating, electric shock, rape, and other forms of sexual violence, along with starvation and deliberate medical neglect. No one in Israel is being held accountable for torture, cruel, and inhuman treatment, because they are not aberration. They are the policy. They are features of a system that operates with total impunity and even takes pride in these violations that are protected by the Israeli judiciary, enabled by military command, and shielded so far from international accountability. The abuse of the prisoners is not a failure of the system, it is the system. And since October 7, at least 98 Palestinian political prisoners have died while in Israeli custody, by the military or the Israeli prison service, as a result of the torture and abuse and starvation and medical neglect. Among them, at least 88 identified prisoners' bodies are still being held by Israeli authorities, not returned to their families, not buried with dignity, but held as instrument of continued punishment. 53 of those were from Gaza, 32 from the West Bank, and 3 Palestinian citizens of Israel. Only 2 of those 88 people were prisoners who have been convicted through a judicial process. These prisoners must be understood within a much larger picture. Israel is currently withholding 373 additional identified bodies in its morgues and military cemeteries since the 7th of October. The total number of Palestinian bodies held from Gaza, the West Bank, and those of Palestinian citizens of Israel stands at 776. In addition to these identified bodies, it is estimated that Israel is still holding approximately 2,000 more bodies from Gaza. Many of them were fighters from the 7th of October. So in parallel, thousands of people from Gaza remain missing, forcibly disappeared. Their families don't know whether they are alive or dead. No information is provided. For the first month of the war, when human rights organizations addressed the Supreme Court in habeas corpus cases to know the fate of many of the missing from Gaza, including doctors and journalists, the state refused to provide this information, and the court permitted this. When some information was eventually disclosed, a few families who had resorted to these petitions with the help of human rights organizations discovered that their loved ones had already been dead for months in detention, while Israel did not even notify the families nor return the bodies to the families. So what we are witnessing is the extension of carceral violence into death. The same logic that confines the living indefinitely without charge, without meaningful legal recourse, and subjects them to abuse is also applied to the dead, and it's part of a formal policy. This policy is based on an official government decision enacted in 2017. Under this policy, bodies labeled as belonging to so-called terrorists, including individuals killed merely on suspicion of carrying out lone attacks, are withheld by Israel, whether in its morgues or military cemeteries. The stated justification was that they needed to be used as bargaining chips to pressure Hamas to return the body of 2 Israeli soldiers killed in Gaza in 2014 and held by Hamas. So the decision was originally applied only to those affiliated with Hamas or those who had carried out attacks deemed exceptional. But in 2020, the policy was expanded to cover practically every Palestinian from the occupied territory. And in 2024, following the death in Israeli custody of Walid Daqqa, a writer, a political prisoner, and a Palestinian citizen of Israel, it expanded the policy again to include Palestinian citizens of Israel. So they're using Palestinian prisoners, Palestinian citizens, like a citizen for citizen, in order using the Jewish nationality law to say that Jewish lives are the one that matter. This bargaining chip policy did not begin with the dead. It was first applied to living detainees and prisoners for decades, until it was exposed by the publication in 1998 of a previously classified Supreme Court decision from the year before. The case involved the detention of 10 Lebanese citizens who, despite having completed their prison terms, were kept in administrative detention for years, and were supposed to be kept there for an undefined period to serve explicitly as bargaining chips in negotiations with Hezbollah for the release of Israeli missing members of its security forces. Most of these detainees had been abducted from Lebanon and unlawfully tried in Israeli courts, and yet even after they completed their sentence, Israel continued to detain them without a legal basis, effectively as hostages. Testimonies from these detainees show that they were subjected to ill treatment and sexual abuse. The Supreme Court, headed by Aharon Barak, initially approved this policy, while its decision remained classified. And once the whole judiciary procedure was exposed after a legal battle, the court reversed its position in a subsequent hearing, holding that Israel can't hold living prisoners as bargaining chips. Yet even after this decision, Israel did not abandon this logic. Two developments are evident. First, Israel continues to detain Palestinians without charge or trial, carrying out mass arrests, including the re-arrest of those released under ceasefire agreements, and often holding them under administrative detention without charge or trial. When October 2023 began, approximately 5,250 Palestinians were held in Israeli prisons. Within 18 months, the number had more than doubled to over 11,000 Palestinians, with at least 6,000 held without charge or trial. Second, as this bargaining chip project has been extended to the dead, we have seen an escalation in the abuse of corpses, including in the manner of their seizure. Since October 2023, this logic has been applied on a mass scale. We have seen footage of Israeli forces kicking and pushing the bodies of men they have killed off buildings. We have seen bulldozers scooping up human remains and dragging them into military vehicles. We have seen the destruction of cemeteries and the violent exhumation of bodies from graves. So bodies are stockpiled, held, and weaponized. Beyond this claimed use as leverage, as bargaining chips, these bodies serve another function, the concealment of evidence. So the right to life carries with it the obligation to investigate and prosecute alleged unlawful killing by state authorities. We know that Israel does not conduct genuine investigations into the killing of Palestinians. The aim of its investigative process, including its court, is not accountability, but shielding. Withholding body makes that shielding complete. When the remains of a victim are held by state authorities for prolonged periods, the possibility of independent investigation is effectively destroyed. Evidence of extrajudicial killing, of torture, and of the cause and manner of death disappears with the body. So this is not a side effect of the policy, it is one of its function. There is also a further concern that needs to be named. Given the documented history of Israel's Institute of Forensic Medicine in Abu Kabir and its long-standing practice involving Palestinian bodies, there is a well-founded fear that some of these withheld bodies are being used for organ harvesting, for Israel's skin bank, and for medical research, like what happened in the past and was documented by the institutional history. The harm also and mainly extends to family and to Palestinian society as a whole. When a family cannot bury their dead, they cannot grieve. They are held in a state of permanent suspension between loss and uncertainty, between mourning and waiting, denied the basic act of laying their loved ones to rest. It is therefore operates as a form of punishment extended to families and as a means of suppressing any kind of resistance to Israel's policies and unlawful practices. All these are evidenced by recent developments. In the recent ceasefire arrangements, all Israeli captives, dead or alive, were returned, yet Israel continues to withhold Palestinian bodies. The few hundred that were returned to Gaza were transformed in batches, often decomposed and unidentifiable, forcing families to attempt recognition under degrading conditions. Only a small numbers of those taken since the 7th of October have been returned, while thousands remain missing. These captive bodies of Palestinians from the West Bank, Gaza, and Palestinian citizens of Israel continue to be withheld, despite Israel having no remaining basis to try and justify their retention for negotiation purposes. Just to conclude, so what holds all of this together, the torture of prisoners, the death in custody, the mass graves in Gaza, the forced disappearances, and the withholding of bodies, is impunity, a structured and deliberate form of impunities that insulates the system from accountability at every level. Through its own legal framework, through military command, through the closure of investigations before they begin, and through the physical disappearance of evidence, all while violations and violence against Palestinians continue to escalate. And we see now with Israel trying to pass the death penalty law and trying to, while the whole international community is moving toward its abolition, its politicians are taking pride in trying to expand it to Palestinian political prisoners and also executing it in the most inhumane ways.
Thank you very much, Muna, for explaining with great clarity the different aspects behind this lesser-known policy of withholding corpses and urging also us to consider the grave implication behind this new law that's being proposed at the moment. And I'd like now to introduce our next speaker, who is Dr. Julie Billode, who is a scholar of human rights, humanitarianism, and international governance. She's a professor of anthropology at the Geneva Graduate Institute, and she will discuss how imprisonment is a central element in Israel's apartheid regime and some of the limitations of humanitarian approaches when trying to support the rights of Palestinian prisoners.
Thank you so much for giving me this opportunity to speak today. It's very difficult to speak after having listened to these heart-wrenching testimonies. I will try nevertheless to offer a broader framework for understanding these practices. And so I would like to focus my intervention on the question of Palestinian prisoners and detention conditions in Israel by situating imprisonment within a broader political structure. My argument is that incarceration is not simply a security measure or a response to individual acts of violence. Rather, it is a central technology of governance within Israel's system of domination over Palestinians. To understand this, we must look beyond prisons themselves and consider how the entire landscape of occupation functions as what some scholars describe as a carceral society, a system in which surveillance, confinement, and bureaucratic control structure everyday life. The first point I want to make is that prisons are part of a governance model to which international humanitarian organizations unintentionally contribute. Over the past 3 decades, indeed, the dominant international framework through which Palestine has been governed have been humanitarianism and human rights. Since the Oslo period in the 1990s, international donors have heavily invested in humanitarian aid and human rights organizations operating in the Palestinian territories. While these frameworks appear to signal concern for Palestinian welfare, many scholars argue that they have also contributed to depoliticizing the Palestinian struggle. In practice, humanitarian governance often shifts attention away from the structural causes of Palestinian suffering, namely military occupation, territorial dispossession, systematic discrimination, and reframes these realities as humanitarian crises requiring technical solutions. This critique has become particularly visible during the current genocide in Gaza, where humanitarian responses such as temporary aid corridors or symbolic relief measures have done little to alter the structural conditions that produce suffering in the first place. But humanitarianism does more than obscure political realities. In many cases, it also becomes integrated into the infrastructure of control that governs Palestinian life. So the architecture of control that I'm describing here manifests itself perhaps most obviously within the prison system, to which the prisons themselves, the detention centers, are only one manifestation. To understand the roles of prisons, we need to examine the broader system of spatial and bureaucratic control that defines the Israeli occupation. Scholars have described how the occupation operates through a dense network of checkpoints, walls, settlements, restricted roads, permits, and surveillance mechanisms. These devices divide Palestinian territory into fragmented enclaves and regulate movement through complex administrative procedures. This architecture functions in a way that resembles the logic of incarceration. Indeed, scholars such as Abraham Bornstein or Eyal Weizman argue that the transformation of Palestine into a carceral society is a strategic component of Israel's military occupation. In such a system, prisons are only the most visible manifestation of a broader regime of confinement. Checkpoints, permit regimes, identity cards, and bureaucratic restrictions also operate as technologies of discipline and surveillance. For Palestinians, movement between cities, access to land, and even family life are often subject to permits issued by Israeli authorities. These permits can take months to obtain and are frequently denied without explanation. No need to say that these permits are no longer delivered at the moment. Entire population are therefore governed through a regime of administrative control that resembles carceral management. The result is a form of political order in which mobility, space, and time are tightly regulated. Therefore, the prison system is a central pillar of this apartheid regime. Within this broader carceral landscape, the Israeli prison system plays a particularly central role. Palestinians from the occupied territories experience one of the highest incarceration rates in the world. My colleague gave the numbers just before me. Over the decades, hundreds of thousands of Palestinians have passed through Israeli detentions and have been subjected to torture and ill treatments that my colleagues have described in great details. This mass incarceration is not only a matter of law enforcement, it is deeply embedded in the political management of the occupation. International human rights organizations have concluded that Israel's systems of rule over Palestinians constitutes apartheid, defined under international law as a regime of systematic oppression and domination by one racial group over another. Prisons are a key component of this system. They serve several functions. First, they discipline and suppress political dissent. Many Palestinian detainees are arrested for political activities, including participation in protest or affiliation with political movements. Second, detention practices such as administrative detention, in which individuals can be held without charge or trial for renewable periods, allow authorities to neutralize perceived threats without due process. Third, incarceration operates as a collective form of social control, affecting not only prisoners themselves, but also their families and communities. Because arrests are widespread, nearly every Palestinian family has experienced imprisonment directly or indirectly. As a result, prisons occupy a central place in Palestinian political and social life. Let me illustrate this dynamic through one specific example: family visits to Palestinian prisoners. After the 1967 war, the International Committee of the Red Cross began facilitating visits between Palestinian detainees and their relatives. Under international humanitarian law, particularly the Fourth Geneva Convention, the occupying power has the obligation to allow detainees to maintain family ties. However, in practice, the process of visiting prisoners has become embedded in the Israeli permit regime. Families must obtain special permits to travel from the West Bank or Gaza to prisons located inside Israel. The procedure is lengthy and highly bureaucratic. Applications can take months to process, and approvals are frequently denied on security grounds. Over time, the humanitarian programs designed to facilitate visits have themselves become bureaucratized and institutionalized within the occupation's administrative apparatus. Instead of simply ensuring that families can see their loved ones, humanitarian organizations often find themselves navigating the complex permit system, producing documentation, and adapting to constantly changing security regulations. In this way, humanitarian initiatives have become integrated into what might be called the administrative infrastructure of occupation. Yet the story does not end with domination and control. One of the most striking aspects of Palestinian imprisonment is the way prisoners themselves have transformed detention into a site of political organization and resistance. Inside Israel prisons, detainees have historically formed political collectives affiliated with different Palestinian movements. These groups organize education, collective decision-making, and protest actions. Mass hunger strikes have been one of the most powerful tools used by Palestinian prisoners to challenge detention conditions and demand rights. These acts of resistance demonstrate that prisons, despite being intended to dismantle political movement, have often become centers of political mobilizations. Former prisoners frequently emerge as influential figures in Palestinian politics, and the experience of imprisonment carries significant symbolic and social meanings. Families of prisoners also organize support network and advocacy campaigns. Women in particular have played a central role in this mobilization, acting as mothers, sisters, and activists defending the rights of detainees. In this way, the prison system has paradoxically contributed to the formation of collective identities and solidarities within Palestinian society. The death penalty bill examined by the Knesset is another attempt at eradicating the Palestinian struggle for liberation and self-determination. So to conclude, the case of Palestinian prisoners highlights the limitation of humanitarian approaches to situations of occupation and apartheid. Humanitarian organizations typically operate under strict conditions imposed by states. Access to detainees, families, and communities often depends on cooperation with authorities responsible for the very system that generates suffering. As a result, humanitarian actors have inadvertently become part of the administrative machinery that sustains the status quo. Programs intended to alleviate suffering, such as facilitating prison visits, may mitigate some immediate hardships while leaving the broader system of domination untouched. In context of structural inequality, humanitarian action risks becoming a mechanism for managing populations rather than transforming the conditions that oppress them. This does not mean that humanitarian efforts are meaningless. For many Palestinian families, the ability to visit a prison relative remains deeply important. But humanitarian intervention alone cannot address the underlying political structures that produce mass incarceration. So examining the situation of Palestinian prisoners reveals something fundamental about the broader political order governing Israel and the occupied Palestinian territory. Prisons are not simply sites where individuals are detained, they are part of a wider carceral infrastructure that regulates Palestinian life through surveillance, spatial fragmentation, and administrative control. This system of confinement is deeply intertwined with what many international observers have identified as a regime of apartheid. At the same time, Palestinian prisoners and their families have transformed incarceration into a powerful site of resistance and political mobilization. Their struggle reminds us that humanitarian responses, while important, cannot substitute for addressing the structural causes of injustice. If the international community is serious about human rights in Palestine, it must move beyond managing humanitarian crises and confront the political realities that sustain them. Thank you so much.
Thank you very much. The broader carceral landscape that is central to Israel's settler colonial system, but also situating the important forms of prison resistance and political mobilization that are important to be aware of and build on. We have now some time for questions. If you could please, before you ask your question, introduce yourself and point if the question is to an individual or to the three speakers in general. I see two questions. We could take one here and one here.
I don't think it's on. Oh yeah, here it is. Yes, I represent a European public law organization, and I'm the ambassador here. We have observer status. And I have a question regarding the judicial process. What percentage of prisoners go through some kind of a judicial process? And all these atrocities that you mentioned, are the ones, is everybody subjected to them, or it has to do with a crime committed? Thank you.
Thank you for that. And yeah, stay of Palestine.
Thank you, from the Permanent Mission of Palestine. First of all, thanks to the speakers for shedding light on this important issue, as the special rapporteur today is presenting a report on torture in Palestine and for Palestinian detainees in Israeli jails and prisons. And this issue has been going on for so long, whether we're talking about withholding the Palestinian bodies. This is a systematic policy that has been going on since 1967, and it's not really related to, let's say, having this bargaining chip. It's a systematic policy just to oppress the Palestinian people and other prisoners, and it's been going on for so long. And if there's numbers, when I'm talking numbers, since since 1967, more than 1 million Palestinians have been jailed, have been detained in Israeli prisons. And thank you, Ms. Julia, for your intervention and statement. This is true. Yes, it's not only a humanitarian issue. We have to target the core issue, which is a political one, which is illegal occupation of the state of Palestine. As we said, this is not an isolated practice. It's part of a systematic policy. If we're not talking specifically about the settler colonial regime and its tools. This is using its various tools of domination and oppression, whether we're talking about its manifestation of the genocide in Gaza, which is a result of decades of impunity, and we're talking about the settler terrorism in the West Bank and all the other policies. I just wanted to thank the panelists for that, and just wanted to point out these two statements. Thank you.
Thank you very much. I'll give now our panelists a minute and a half to each, if they want to reply. Who would like to say something first?
Better placed. Yeah.
You want to say something? Okay.
يعني بالنسبة للسؤال كالتالي الجواب. إسرائيل من 7 أكتوبر قامت باعتقال آلاف من قطاع غزة ومئات من سوريا ومن لبنان، والآلاف من الضفة الغربية باعتقالات بدون محاكمات، اعتقالات إدارية بدون محاكمات، بدون تهم، بدون شبهات. كل شخص اليوم من قطاع غزة، وعلى الإطلاق إسرائيل من 7 أكتوبر حتى اليوم لم تقدم أي إنسان غزي للمحاكمة، سواء المدنيين أو مما تسميهم من قاموا بأعمال معينة نهائيا. أنا كمحامي متابع لهذا الملف أكثر من عامين لا تستطيع إسرائيل محاكمة أي إنسان، كلهم بدون محاكمات على الإطلاق. فإسرائيل تتعامل بنفس آليات التعذيب والتنكيل والاغتصاب بحق كل المدنيين وكل الأسرى المعتقلين بالسجون.
Did you want to add maybe something?
Just to add to that, Israel has, first of all, it uses administrative detention, and it uses allegation of terrorism in order to prohibit lawyers like Khaled from seeing, from the prisoners from seeing their lawyers. And since October 7, it has amended its law. It has a illegal combatants law, which is like an unlawful law that Israel and the US have. And through this law, it prevents prisoners from seeing their lawyer, from seeking counsel for prolonged periods, and it's completely disconnecting them from the world, also by banning family prisons and by banning the ICRC from visiting them. So they are completely secluded. And as for your comment, yeah, thank you for that. I think that we're all talking about these violations, whether for the living and for the dead, as part of a settler colonial violence, as part of what has been defined that is based on a logic of elimination. The genocide in Gaza is one of its manifestations, but these logic have been ongoing since 1948. And through my research, I also show that the targeting of dead bodies is part of its logic. It's part of inflicting harm and inflicting violence that is not, that it's not only about the dead, it's about the families, it's about the communities. The use of mass graves, it was used in 48, it was used in several other incidents when Israel resorted to mass violence, but it's a way in order to make us disappear, in order to also rain terror on us, for us as part of its technique for ethnic cleansing. And so yes, it is.
Okay, unless there are any final comments, we'll have to end it here for now. We don't have any much time left, so thank you very much everyone for coming today.